humidity back up, but at least right now, no big weather makers on the way, so we may have an extended stretch of fairly quiet weather that could take us over the next 10 days or so. Meteorologist Grace Anello in first thing tomorrow morning. She'll have the latest details on that work week ahead and what you can expect headed out the door for that morning commute tomorrow.
All right, thanks so much, Jeff. Thank you, Trevor. WAAY 31 gives you 24/7 coverage you can count on, local news, breaking news, and severe weather.
Of course, watch WAAY 31 on all of our streaming platforms and download the only weather app with 3 live Doppler radars.
Don't go anywhere. WAAY 31 LawCall is next.
This is WAAY 31 LawCall.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight it's back to school night. We're talking about laws related to being back to school. Have your kids been back for a week, or some schools been back about 3 weeks now? Call in your questions on everything from what to do if you've got a bullying situation in your school and the school's not doing anything about it. What if your child gets injured while at school? Do you have a lawsuit with that? How about talking about changing school zones if you and your ex are arguing over which schools the kids should go to? What can you do about that? School-related legal issues, call in the 31 Law Call number 256-536-0077. You can also now text to that same number. So if you're a little shy and don't want to go on the air, you can text in your question and we'll pull them out. You can also email a question any day of the week. You can send any legal question to lawcall@waaytv.com, and when we get to a show that's on point, we'll pull some out. We've got some of your email questions tonight. Getting us started tonight, Michael Timberlake's here from Timberlake, League and Brooks. Good to have you back.
Great to be here.
Back to school time. You just got your oldest off to college.
Yes, I've been down there with the U-Haul. You know.
Big change.
Yes.
Big change.
Yes.
Kids growing up, everybody's got kids back to school. Before we start taking your questions and we get the first callers locked in, we've got tonight's You Make the Law Call clip. So we pulled some video off of YouTube. It looks like a beautiful day for going out, taking a walk, taking a drive. Okay, he's going to be just fine. But watch what happens over here to the left.
Oh.
And it's not over yet. Hold on, you're going to see it come right back. Holy cow. Okay, so we're going to play it over again. It looks like the guy coming from the left runs the light, maybe. Let's look at it again. So,
well, bless the pedestrian's heart.
Yeah, thank goodness
I mean, I'm sure he's scared to death.
If that's what's happening here, somebody running a light, is there any legal defense for running a light? Can you?
You really can't. And it's clearly it's an intersection situation, so you've got the traffic control device controls the intersection, and you've got to monitor the traffic control device. So the car that was at fault for running through the light is going to be at fault not only for injuries to the car that they immediately hit, but they're also going to be responsible for injuries and damages to any other car that the other car hit, like the car that was going the other direction where the car ended up on its roof. So you're going to have responsibility for all of those people in that situation. Where it gets complicated is you've got one person that's caused injury to potentially 3 other people. And then how is that going to work out? Insurance policies are typically written in their increasing amounts. So you have a $25-50 policy, $25,000, $50,000 policy, $100,000 policy, or $250,000, $500,000.
Okay.
So what it means is that you've got a $25,000 per person limit that they will pay, or $50,000 aggregate. Total. So in this situation where you got potentially 3 people that are going to be there, you don't have $25,000, $25,000, $25,000. You only have 50 total, and no one person can get more than 25. So it really, the insurance is limited in that situation. So the more people you have involved in it, kind of the more difficult it is, and the more complicated it is to recover.
So if the insurance company says, okay, yeah, you've got at least $50,000 worth of damages here, take it.
And they're going to go here.
Here, take the $50,000.
Take our money.
How does it get divided out between the different people?
Well, it's
the most hurt.
Yeah, it typically is one of those things where we either can work together with the other counsel for the other people, or directly with the injured people, or the insurance company has an opportunity to interplead the money, which is just pay it into court and say, hey, we owe all this money, y'all figure out how to divide it, or let the court figure out how to divide it. And under those circumstances.
Would they ever just say, okay, this person's really hurt and this one's not hurt so much, so we're just going to give it all to one person? Or do they try and balance it?
Potentially, but then they're going to, if they pay out all the money to one person, and then somebody else has a claim that's in excess of their policy limits, then they can really put their insured in a box and say, because then the person that is responsible is personally responsible. Their insurance has all been paid out, not to their, not at their direction, and then the insurance company can be on the hook for anything in excess of the limits.
Okay. Gets complicated.
Yes, it does.
So tonight we're talking about back to school, injuries that might be related to back to school, and legal actions that might be related to back to school. Let's talk a little bit about are teachers immune? So they're doing their job. If something happens on their watch, how much protection do they have because this is their job?
Yeah, I mean, teachers in Alabama have a lot of protection. They have what we call state agent discretionary immunity, or state agent immunity, which means in general they are a sovereign, the state cannot be sued, and so they are agents of the state. So in most situations, it can be very difficult to sue. You can't sue the state, but if you sue the teacher individually, in most situations they have what's called discretionary immunity. And what that means is, as long as they are doing something, as long as they don't do something that violates a bright line rule, a specific direction either in their employment contract or in their policies and procedures, if they're doing something that's discretionary in their job, then they have immunity. Then you cannot sue them. And it can, and that's a lot of what teachers do. It's basically a judgment call defense. If they're doing something that they have to exercise judgment, a lot of times they are immune.
Okay. You see stories sometimes where some teacher gets the wild idea to tie a student in a chair or something like that because they keep getting up. That seems like that crosses a line.
Those are the things that when it gets to intentional conduct or quasi-intentional conduct, or just, if they just clearly disobey the rules, the written rules of the school or the state when they're doing their job, they can be individually liable for their actions. The AEA, the Alabama Education Administration, the teachers union, typically provides coverage or defenses for those folks that are union members, and you can deal with that. And so there can be insurance and lawyers involved in those types of situations. But you're always going to face this issue about, well, was their action discretionary, or is there something that you could move against the teacher on?
Yeah, punishments have changed a lot in schools since our day, right? Not a whole lot of spanking in schools or physical punishment
There's
anymore.
a whole lot of different types of things they can do, and with that comes a lot of rules in terms of specific direction about the way teachers can handle themselves, the way they can handle disruptive students. I think it's good for the teachers because it provides them clear direction, but at the same time, it is a lot different than what it was when we were around.
Yeah. The 31 Law Call number, 256-536-0077. You can also text to that number. We got in an email question. This was from Lisa. Lisa says, can the school be held liable if my child is injured by another student during school hours? The school, it kind of comes back to what we were just talking about. So another student injures your student, then your first claim would be against that other student, and directly against that student, regardless of whether that child is a minor or not. If the child's a minor, you can still, file a claim against that student for their actions, and a lot of times, there can be successful claims under those situations. Then you look at, is the school responsible? Was there lack of supervision? Was there a set-up situation so that the teacher or the school administration knew or should have known that this was going to happen and they didn't take action? If you can prove that, then you may be able to make a claim against the school, but the primary claims can be against the principal wrongdoer. how would you prove that the school knew something is likely to happen?
You would have to look, again, you go back to, what are their records? What do they have? You have to have some information to indicate that this was an ongoing problem. Sometimes that just comes from repeated, instances of people having problems with one child and going to the administration and trying to take care of it and having, that problem not being resolved. And if it happens over and over and over again, then that leads to potential liability for the school administration and the board.
Okay, talk about who would pay. So you're saying if one student injures another student, you could bring a claim or a lawsuit for your child,
Right.
and you'd be suing
Sure.
the other child.
Right.
That's how you file it. What are you going to
Yeah.
get? I mean, do you get money from the child or from the parents?
Typically, if it's a situation where there's not necessarily intentional conduct, or you can look at the conduct and say that it was that this was potentially reckless conduct or careless conduct, but wasn't intentional, you can then look to the child's potential homeowner's insurance policy that they would have with their house. So if their parents own a home and have to have insurance on the home, there is a liability insurance rider or policy or as part of the policy that would potentially provide coverage for the child for careless or even reckless acts or injuries to somebody else, even though they're not in their home or on their property. If they're outside that property, the policy still provides for coverage in that situation.
But if they did it on purpose, you're saying the insurance probably wouldn't cover it. So
Most insurance companies or most insurance policies that are written like this will cover, reckless conduct, careless conduct, but intentional conduct. If there's something that is directly intentional conduct, there are exclusions for that, and that becomes kind of a gray area. Will the insurance company cover that? Typically, if there's a question about whether there's coverage, an insurance company will send the wrongdoer or send the potential wrongdoer, they're insured, a letter saying, look, we've got a potential situation here where we would not extend coverage to you, so we're going to provide coverage to you or provide a defense to you, hire an attorney for you under what is called a reservation of rights. And simply what that means is that the insurance company is going to do what they would do normally in a situation, short of paying out money, and they're going to investigate the situation. And if it determines that they have coverage, then they will go ahead and pay or extend the coverage to you. If they're determined there's not coverage, then you're not put in a bad position because you relied on them. You would still have counsel up until the point where they denied the coverage.
we got in a text, parent writing in, my child's in a local high school band. During a recent band parent meeting, it was stated that if the parents don't sign up to work on the concessions, that the director would pull the student and make the student work concessions during the game instead of allowing the student to play with the band during the game. Is that legal? You didn't sign up to work concessions. You signed up to play in the band.
Well, you know,
Can you do that?
You know, a lot of it depends on, you know, what the situation is in terms of what the booster situation. I don't think that's probably kosher in terms of what the band, the situation with the school is. You know, the students should have an opportunity to play and you know, and perform, you know, if they live up to their end of the bargain. Just because a parent doesn't, you know, can't or won't, you know, engage in the booster program, I don't think it should have any impact on that student. So basically you're unfairly discriminating against a student who's done everything right because their parents aren't willing to participate, and that's not really fair to the kid.
We're going to take a break. We'll be right back answering more of your questions. We've got some more text coming in. Back to school questions. Stay with us.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. Tonight we're talking about back to school issues. The Law Call number, call in 536-0077. You can also text to that number. An ongoing case, virtual school sign-ups that was not a real school?
Well, yeah, and it happened during, they had an issue during the pandemic where you had some, superintendents, principals, administration of schools in North Alabama, and what they were doing is they were getting state funds for kids to sign up for these virtual programs, and they were releasing the kid. They were taking the information they had through the state and using that information to sign these kids up and getting the tuition, but not providing any services for the kids.
That's an easy way to make money.
Yeah, so, and a lot of it was criminal activity, and you have a lot of these folks that have gone, that have gone through prison or have plea deals and have been prosecuted criminally. We're pursuing claims civilly for the identity theft, the problems that they've got, like taking these kids' identity, using it for their own good. And so that's been ongoing for a while, and it's deep into discovery, and we'll see how it goes.
Very interesting. We also wanted to remind people about, you've got the Race for Justice coming up.
Yes, yeah, the Race for Justice, and this is a program through the Madison County Volunteer Lawyer Program, and it's a great program that basically takes pro bono cases and assigns them to private practice lawyers that are willing to donate their time to take care of people, and they do all kinds of civil cases. Criminal lawyers are appointed for you by the court. This is not that. This is civil lawyers that are spending their time to take care of people that can't afford lawyers. They've got their big fundraiser is on Labor Day, and it's the Race for Justice. If you are inclined to get out and run and do your thing, please register. It's a great race, good times, and it's coming up here in the near future, and we'll be there, and we're excited about it.
Excellent. Okay, we got in a text. Can parents contest with the city if a teacher falsely writes up a student after another teacher confirms to the parent that the situation was mistaken identity?
No.
What can you do? What do you recommend?
You're basically, you go through the hierarchy there. You go through, you address it with the administration of the school. If you can't get to where you want to be with the administration of the school, then you take it up to the school board, and school board, the superintendent. You work through the system, and then if you can't get your answer to the superintendent, then you take it up with your school board member. But really, the idea is to be calm, cool, and collected through the process. Typically, the people that are hysterical about things like this cause more problems for themselves than they create. Than they solve. So it's a situation where you want to make sure that you do everything you can to take care of your kid, but go through the right channels and make sure it gets processed correctly.
Okay, let's talk a little bit about sports injuries.
Right.
If kids are out playing sports with their schools, if they get injured while they're out there, is that the same kind of injury that we're talking? Can insurance cover something like that, or where does that fall?
Most of those injuries would fall under what we call assumption of the risk.
Okay.
That you're assuming the risk of injury by engaging in a certain activity. Now, if there is something unusual about the activity, maybe intentional, maybe something that was, after the whistle. If there was something that was could be deemed something other than a risk that you didn't assume, then that's a potential actionable thing. We have seen claims against trainers or doctors or potentially that are treating on-field injuries. A lot of times those can be difficult because you're dealing with a traumatic situation, and these trainers or doctors are typically donating their time as volunteers, and so there can be protections afforded to them in that capacity. But in general, sports-related injuries are typically not anything that we see in the personal injury world very often.
Okay, what if you are the visitor, you're there watching, and something happens to you. Maybe whether it's the ball flies out of the park and it cracks your windshield,
Right,
or it
right.
hits you in the face while you're sitting there watching and you're injured. Are you assuming the risk by being there?
You know, we used to, like when I was in law school, we talked about that, you know, that you'd look at the back of the ticket and it would have a big disclaimer on there that, you know,
Yeah.
not
responsible
responsible for anything,
Yeah,
you know,
yeah.
but if you're, by purpose of, virtue of this ticket, you know, we're not, you're releasing us from any liability for any, sports-related hazards. That is, typically, we don't have tickets anymore, so
Yeah.
that's not, typically something you see. But in general, it is the same as an activity that you assume the risk of. So that if you're at a baseball game and you get hit by a baseball, that's something that could happen. You voluntarily assume that risk when you go there and go and participate. Now, if you're behind the fence and there's a big hole in the fence, that's a different story.
Oh, okay. That might be an opportunity to do something.
Yeah.
We had talked a little bit about school zones, and we were talking about kids going back to school, and school
Sure.
zones in an area that falls into family law, which I do. People are oftentimes asking, what if I disagree and I want my child to go to my school zone after the divorce, and my ex wants the child to go to their school zone? How do we figure that out?
Yeah, I mean, how do the schools, they basically have two parents that they
Yeah.
have to answer to in that situation.
Yes.
So what does the school do, or do they have to offer them to go to either school, and then who makes the decision?
So generally the order will include in there some orders about who is assigned ultimate decision making for various areas, medical, educational. So if you're going through a divorce, one of the things that you may want to be thinking ahead of is that area important to you? Do you want to be the one that's in charge of ultimate decision making for education? And that parent would likely be the one that's going to get to choose which school zone they go to. Alternately, you can write in the language to a divorce settlement that the parents agree the child will go to such and such school zone for so long as either parent resides there, and if neither parent resides there, then here's the backup plan. So you can take away some of that power from the other parent if you plan ahead for it.
Right,
so talk
right.
to your lawyer about
Well,
that.
and that gives you basically options. So,
Yeah.
if you can be in one school zone or the other school zone, depending upon what they can agree on, and that depending on where you live, that may one school zone may have a better option than another one. So that's a great point that you need to pay attention to if you're going through a divorce.
Okay, you've got the college kid going away, and you've wanted.
Well,
to
he made it through his first semester. He did not get arrested, and he made good grades.
Excellent.
That's
all that you need.
Yes.
Over the age of 19, though, you're paying all the bills, but a little surprise for folks out there that you think you're going to be in control.
Yeah, the one thing at orientation they made it very clear is that because your child, if your child is over 19 years of age, he or she is of the age of majority in Alabama. And that means that you as a parent no longer have the power over him or her to get all their information. So their healthcare related information, their grade related information, even their billing information for the school that you're paying for, you have to have the child, or not the child, you have to have your child, who is now an adult's permission to give you that information so that you can find out how much you have to pay them, what the grades were, and if they're going to class.
Wow.
Yeah, I mean, it's crazy.
A little different. You've got an adult on your hands.
I know, it's absurd.
We're going to take a break. Be right back, answering more of your questions about back to school. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch. Michael Timberlake with Timberlake League and Brooks in Huntsville. They are personal injury attorneys, so that's everything from car accidents to medical malpractice. 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about the law that way.
And Sharon practices family law in North Alabama. She does a great job of all things child custody, divorce, anything child related, family law related. 256-539-7337 or SharonFamilyLaw.com.
Thank you. Thanks for all your calls and questions. Glad everybody's back to school safe. Have a good week.